Hi, Cybersecurity Law class. This is Professor Opterbeck. I just wanted to touch base at the start of week 2. I was very happy with your discussions during week 1. I think all of you picked up on some of the key themes in the Yahoo case and in the Wayfair case. And as most of you noted, that Yahoo case, it's a little dated in today's internet era, but it does raise all these really interesting issues about jurisdiction and about values and about borders and even about really what is the internet? Is it the hardware that's located in a place? Is it the content that is really more kind of ephemeral? All those questions came up in that Yahoo case. And as we'll see throughout the semester, they're really not all entirely resolved. If you go on and take the national security course next semester, we'll also talk a bit more about terrorist threats online. And we'll talk about that a bit at the end of this semester when we do computer crimes. But next semester we talk about responses to that, and you'll see that this is a really live question today. The issues raised in that Yahoo case are a live question today. There are some countries like Australia that have adopted laws that criminalize social media platforms that don't actively police terroristic or hate speech. In the US, we've generally taken a very different approach to that with an immunity under Section 230 of the Communications Decency Act. But all of that is very much under debate and under discussion. So you'll see that issue remains very live. I thought it was really interesting, some of your conversations about the Wayfair case. It felt like a lot of you thought that the result in Wayfair was the right result, and maybe it was the right result, but you should know that in the internet law community, that was a really contested issue and a really contested case. And from the very early days of the internet, there was a lot of fear about, or concern, I should say, about how tax law would affect internet commerce. And there was a kind of long-standing belief that there shouldn't be state and local taxes online. In effect, you shouldn't tax the internet. Of course, that wasn't ultimately the result that came out in the Wayfair case, and the court really bought into this argument about how the internet impacts local retailers and how local governments might need to continue to assess those taxes to make, quote, a fair playing field. A question to ask there is, what are state and local taxes really for? And a lot of what they're for is for the infrastructure, emergency services, roads, things like that. And to what extent do these internet retailers really utilize that infrastructure? Or to what extent is this really kind of a money grab by the states, number one, and number two, sort of a concern by some of these brick and mortar retailers about a way of business that is simply being outpaced by the market? So very interesting questions and great discussion for last week. For the materials coming up for this week, you'll see that this is another week where we're sort of staying at a very theoretical level. We're continuing to ask what the internet is, and then we're also asking sort of a big question about what law is. One of you sort of, I think, somewhat jokingly in your comment from last week said, I didn't expect to be talking about the Peace of Westphalia in an internet law course. And I love that kind of stuff, but also we talk about it because the internet does change a dynamic of law and territories that has existed for a few hundred years, or at least potentially changes it. And that's one of the things we talk about this week. I know this week's material can be a little bit abstract, but stick with it, kind of enjoy it, have fun with it, and I think you'll see as we go through the semester how it lays some foundational ideas for things that we'll talk about throughout the semester. So I hope you're all well, and I look forward to seeing you online during the week.